Good morning. My name is Rich Sloma, and welcome to today's New York State Archives presentation of Legal Discovery, the Role of Records Management. Today's presenters are Jennifer O'Neill and Monica Hauck-Whealton. This session is being recorded and will be available for future viewing. If you have questions, please type them in the chat feature to the right side of your screen, and we will answer them at the end of the presentation. And now I will turn the presentation over to Jennifer.
Great, thanks, Rich, and hello and welcome to everyone today. It looks like we have a good crowd. And as Rich stated, I'm Jennifer O'Neill. I head up our scheduling and state agency services. And joining me today as a co-presenter is Monica Hauck-Whealton. She is a records advisory officer for miscellaneous local governments. So today we're going to share some background information on state agency and local government obligations related to legal discovery, and we'll provide you with some advice on how good records management practices can make compliance with discovery-related requirements much easier. We would encourage you, if you have any questions or comments, to add those to the chat. We will attempt to answer them all at the end of our formal presentation. So first, we need to issue a bit of a disclaimer here. Neither Monica nor I are attorneys. More specifically, we're not your attorneys. So please note that content within this presentation should not be interpreted as legal advice, and you really should, and we would strongly encourage that you work with your own attorney to get good, proper advice on any of the information we've shared in this presentation, and if and when you get a discovery request. So today, this is our agenda. We're going to start out by talking about the types of litigation that local governments and state agencies can expect to encounter. There are a lot of legal terminology that can be complicated to understand. We'll define those so that we're all on the same page. We'll also talk about the role of records management staff in responding to litigation. And then when I turn it over to Monica, she will talk about discovery requirements for civil and criminal cases, including some new ones. And she'll also talk about records management procedures to ease compliance. So any local government or state agency entity may become involved in litigation. So some of you may work for entities that have some sort of a local, or have some sort of a law enforcement role. That could include working for a local police department, the state police, and then there's also agencies that have a law enforcement component. Those would be agencies like the Office of the Attorney General, the Department of Environmental Conservation, SUNY University Police, and the Department of Taxation and Finances Civil Enforcement Division. There's also particularly agencies who are engaged in the enforcement of the state's regulations. So that those enforcement actions could include monitoring compliance, conducting inspections, issuing permits, and initiating administrative or civil actions for violations. All government entities in the state are subject to what we call Article 78 proceedings. This refers to Article 78 of the Civil Practice Law and Rules, which governs civil procedures. And basically, anyone can challenge the decisions, actions, or inactions by governments, their bodies, or officers. These are filed in Supreme Court, and they generally have a really uh, brief, quick turnaround. Usually it's 4 months of receipt of final determination. And some examples of that can include challenges to a FOIL request denial, challenges to a zoning decision, or challenges to professional license revocation. And then there's general legal disagreements that come up both in the public and private sectors. So for instance, did a consultant meet their obligations under the contract describing work to be completed? So is there a contract dispute? Did someone get hurt and claim that it's due to negligence or inappropriate action by a public entity or employee? So there could be maybe a personal injury claim against your government. So these are all reasons that your government may become involved in legal action or litigation. Sometimes it's part of a stated mission, and for others, it's the best mechanism for forcing compliance or righting a wrong. And sometimes, you hope that this isn't the case, but sometimes it's government entities that are accused of a wrongdoing. So in today's session, we're going to focus on one particular aspect of litigation, and that's discovery. And we're going to look at it within the framework of records management. So it's really important that you have good records management practices in place. Um, this means that your records are going to be well organized and documented so that you can find records that are needed to prove your case, and you make sure that critical evidence is preserved. You've also you also have good documentation that you applied retention schedules appropriately, and you've documented the destruction or disposition of records properly. This might also mean that you have audit trails in place to make sure that the appropriate people were accessing your documents and that they weren't altered in some way. Good records management practices can also reduce the quantity of records needed to review because you've destroyed them according to your retention schedule, and this will allow you to more quickly retrieve your records. Poor records management practices, on the other hand, can not only hurt your case by preventing access to useful information, but can also lead to court-assessed penalties if the judge determines that your organization did not maintain or provide access to records as they should, or they intentionally destroyed records to prevent such access. So let's define what discovery is. So when we say discovery, it's the pretrial process where parties exchange information, evidence, and facts relevant to a lawsuit to prevent surprises at trial. During the discovery process, it enables both sides to gather evidence, evaluate strengths and weaknesses of their case, and facilitate settlements. So both sides, plaintiffs or prosecutors and defendants, are obligated to supply copies of records to each other. We're going to look at different requirements for discovery for both civil and criminal matters in later slides. So there's two different types of cases. There's the criminal cases and civil cases. Criminal cases involve the government prosecuting individuals for violating public laws, and they could carry penalties such as jail time. So think about things like theft or tampering with physical evidence. This gets at that law enforcement role that we talked about just a couple slides earlier. And compare that to civil matters, which involves private disputes between parties who are seeking compensation or a specific performance. With criminal cases, they require proof beyond a reasonable doubt, so really high threshold. Whereas civil cases use a lower preponderance of the evidence standard. Criminal cases are governed under the New York State criminal procedure law, and there may be also, if it's a federal, involves federal laws, there's a federal equivalent. And then for civil cases, they're governed under the New York State civil procedure law and rules, and there's also a federal equivalent. We're going to look at a series of different terminologies. The first one here being discovery demand. So a discovery demand is the formal written request made by one party to another in a lawsuit to obtain evidence, documents, or information relevant to the case. And this is done before a trial if the case comes to a trial. You may also hear people call this notice of discovery and inspection, or it may also be referred to as demand to produce. The discovery demand can take several forms. Today we're focused on the form that is request for production of documents, but there could also be request or requests for an written questions to be answered, for statements to be issued, or depositions. Another term that you may run across is subpoena duces tecum. This is a legal document that specific documents or information pertinent to a legal proceeding be produced by someone other than the named party. So contrast this with discovery demand, which is demanding documents from the party involved in the case, versus this one is seeking documents from a party outside of the case. And this comes from the Latin term, which means you shall bring with you. These can be issued by the attorneys involved in the case. They could be issued by the court clerk, and that's often the case in civil matters. It could also be issued by federal agencies, U.S. attorneys and district attorneys who are involved in investigations. And also they can be issued by administrative law judges who can be found within state agencies. So there's also litigation or legal holds. And these are, this is a formal process that's used by organizations to preserve all forms of relevant information. And this includes both electronically stored information, also called ESI, so essentially electronic records, and physical records, so records that might exist on paper, on microfilm, or other formats you may have. And keep in mind that legal holds should go into effect when you anticipate or are involved in litigation. It basically suspends the normal document retention and destruction policies to prevent destruction of evidence. So even if you have a record that's approaching its retention period. If you hear that there's going to be litigation, you need to suspend disposition of those records until the litigation hold has been removed or the records aren't responsive. So generally, your legal office is going to take the lead on coordinating responses to litigation. Um, but as a records management person, you have some really important roles in the whole process. So we're going to look at in the next few slides 4 areas or 4 roles where records managers can provide really helpful uh, activities. So records managers can help identify responsive records and their locations. They can also document records that have previously been destroyed. They can retrieve potentially responsive records that may be in inactive record storage. And they can also help to apply litigation holds. So let's dive a little deeper into these areas. So I've found that generally records managers have a really good understanding of the functions of their government. And if they don't know something about their government, they usually know who to ask to learn more about that area of government. So a records manager is likely going to know who is creating or receiving records that might be responsive. If Another good resource for answering this question would be to consult retention schedules. Retention schedules are usually organized by function, or they might be organized by unit of government. So looking at the retention schedule, you can see where a potential responsive record might be found. The retention schedule will also help identify what the retention period is and whether those records might still even exist. So if you have received a request for a record from the 1980s and the retention schedule says a 6-year retention period, then you may be able to safely assume that that record was destroyed a number of years ago. Records managers usually have control over an inactive storage area for the government, or if it's a state agency, you might be involved in the transfer of inactive records to the record center. So you'll have a good idea of where inactive records may be stored. Also, for state agencies, don't forget that sometimes some records might be stored at the New York State Archives if they have historical value. So if you're looking for your agency records, you may also need to check our archival holdings. And also keep in mind you may need to check to see if records have been checked out of storage. So I thought it would be good to use this slide to illustrate a recent meeting that I was involved in with a state agency who is involved in handling claims under the Adult Survivors Act. And you might be aware of this act. There was a recent window that allowed survivors of abuse to retroactively bring claims against entities. Um, so in the course of that conversation, um, this agency reached out to us to see if the archives had any responsive records in our holdings. The agency told us that the courts are not satisfied with agencies pointing to their use of retention schedules alone. The courts have noted that retention periods are minimum retention periods and are insufficient proof that records were actually destroyed per the retention schedule indicated in the schedule. So the courts are requiring that agencies do a comprehensive search to confirm whether or not they have the records in question, and also document how they perform that search, because that may be something that needs to be shared with the court. Also obtaining affidavits from agency staff that a diligent search was conducted. And then finally, the courts are often requiring that agencies produce documentation that records were destroyed. So these might include destruction or disposition forms. And you may want to consider holding on to these forms longer than the 6-year retention that we indicate in our retention schedules, especially if it's something like the Adult Survivors Act, where the window may reopen at some future date. So records managers will retrieve any potentially responsive records from inactive storage areas, or, if they're checked out of storage. Um, Certainly misfiled records are problematic, if you can even find them. And keep in mind that you also may need to not only identify responsive records from paper records, but you may need to be involved in identifying electronic records or records stored uh, elsewhere. Um, if you have to apply a litigation hold, you need to make sure that disposition or destruction does not occur. And you'll need to make sure that this is done for records in any format, paper or electronic. And this applies even to records that are past their disposition date. So records that you should have legally destroyed, but did not for whatever reason. Um, the next term that we're going to look at and define is spoliation. So this refers to the loss, alteration, or destruction of evidence, whether intentional or negligent. And this has gotten a lot of focus in the past few years, especially with electronically stored information, because it's a lot easier to alter or destroy electronic records. Um, we're going to look at an example that will help to further illustrate spoliation in an upcoming slide. So we're going to look at this case study, which is Zubulake versus UBS Warburg LLC. And this was an employment discrimination case that Zubulake brought against her former employer, UBS Warburg. And this was the initial case occurred in 2003 in the U.S. District Court for the Southern District of New York. And it was really groundbreaking in terms of its rulings on electronic discovery. The case established some key principles for preserving and producing electronically stored information, particularly emails on backup tapes. So the gist of the case was that the plaintiff had about 450 pages of emails. However, the defendant was only able to produce 100 pages related to the case. So the plaintiff requested that the defendant check their backup tapes and other archiving media to find additional emails. And, the defendant said that the search would be an undue burden, and expense, and wanted the court to shift the cost of production to the plaintiff. So the judge had to decide, who should pay the cost of recovering electronically stored information. And the judge established a multi-factor test for when the responding party should bear the cost of restoring electronically stored information, ruling that cost shifting is not automatic and should not be used to deny meritorious claims. So essentially, U.S. Warburg was responsible for 75% of the recovery costs. They were also penalized or sanctioned uh, for um, uh, for spoliation of the records. This led to an adverse inference instruction for the jury, meaning that the jury should assume that the lost emails were unfavorable to UBS, and that's why they destroyed them. This case underscores the importance of effective records management and preservation practices, and shows that organizations should take proactive steps to ensure the proper retention and production of electronic records, even when dealing with legacy data, to avoid potentially severe legal penalties. So you've probably noticed, and you'll see in the next slide, that there are a lot of steps involved to make sure that you do a thorough and careful job finding any potentially responsive records. But there's also a time factor in place, so you need to do this quickly. So I also wanted to, as an illustration of this slide, take you through a process that we recently followed. So we were involved in a subpoena request for an agency who was involved in a court of claims case. So the agency had identified that there may be potentially responsive records stored at the state archives as part of our archival holdings. So they subpoenaed us. The subpoena was 12 pages, so it was very detailed. It identified names and subjects that we were supposed to use as subject terms to look across the records that we have in our holdings. Um, we spent a lot of time uh, seeking clarification with the attorneys to determine what the scope of the request should be. So it was a 10-year period, what formats they wanted the records produced in, and the timeline for producing the records. So I should say that it took a considerable amount of staff resources on the part of the archives to respond to this subpoena. We had about 10 staff people. Um, uh, it equated to 365 professional staff hours searching pretty much full time for a 3-week period. And we uncovered about 1,000 responsive records. Most of these were electronic records. So still and moving images, press releases, web pages, reports, publications. And we had to produce copies of all these records in electronic format. We also were required to compile an index of all of these responsive records. Um, and the records were stored in different locations, so that added a level of complexity in retrieving the records. So I guess the moral of the story is to give yourself sufficient time and, take the time to make sure that, the subpoena request or discovery request is clear. That should hopefully save you some time in the long run. So with that, I'm going to turn it over to Monica.
Thanks, Jennifer. Can you pass the WebEx baton to me, please?
I am attempting to do that,
Okay.
but
Well,
first, go ahead.
no problem whatsoever. Oh, there we are. Well, as Jennifer said, there are different requirements depending upon a matter is a criminal case or a civil case. And right now we're going to get into the nitty-gritty of some of the requirements for each case type. Starting with criminal cases because, quite frankly, they tend to have a tighter timeline and the requirements have changed more recently. Under the Discovery for Criminal Justice Reform Act, which was initially passed in 2019, those who are responding to criminal cases now need to provide a greater variety of records for a greater number of cases, and they need to do it more quickly than before. So obviously, when this passed, it drew our attention because we realized that records management on the part of the governments who are, participating in these cases was going to make such a difference in their success with complying with the new requirements. As I said, the act was initially passed in 2019. As part of that act, former Article 240 of the Criminal Procedure Law was repealed and replaced with a whole new article, Article 45, including the new discovery requirements. And then those requirements have been revised multiple times since that passage, first in 2020, then in 2022, and then again in 2025. That means that any advice that we give during the next few slides about compliance with the Act is timely. If you are listening to this webinar after March 19th, 2026, you may want to verify that no amendments have been passed for Article 45 and that the requirements have not changed. But again, as Jennifer said in the beginning of the presentation, you really want to talk to your own counsel. They're going to have a good understanding of what the requirements are at the time that you're responding to a discovery demand. Back in 2019, when things changed from Section 240 to 245, the biggest change was the creation of a requirement for automatic discovery for the defense. That means that instead of the defense creating a list of the records that they wish to have access to and providing that to the prosecution, the prosecution now needs to automatically pull copies of most of the records responsive to the subject matter of the case and prepare them for release to the defense. There are exceptions, though. There are certain types of records that you can argue should not be released for, protection of vulnerable people, for example. There's also the change, which has changed between the initial passage of the act and now, that if the defense can access records through a subpoena ducis tecum, prosecution does not need to obtain it on the defense's behalf. The defense can request those records themselves. Another big change that happened is the due date for discovery for criminal matters. It used to be based upon the date of hearing or trial. Now it's based on the date of arraignment, and that is very significant. Take a quick step back. What is arraignment? Arraignment is when the defendant is formally notified in the court of the charges against them. So for a case where the accused might be sent for prison, the deadline for disclosing records to defendants is going to be based upon the date of arraignment. So that means that whether there's a trial or not, whether there's a hearing or not, and for a lot of cases, it does not get to that point. You're still going to have to do discovery. Whereas previously, you might not have had to do discovery. And of course, since arraignment happens before the trial or hearing, you're going to have to consider discovery earlier in the process. Even though there are deadlines for providing records, and of course, under reasonable circumstances, you may be able to get an amendment to the deadlines, Prosecutors should provide automatic discovery responses as soon as possible. But under normal circumstances, if the defendant is currently in custody, automatic discovery should be provided within 20 calendar days after arraignment. If the defendant isn't in custody, you have 35 days after arraignment to provide discovery. The good news is that not every type of case requires automatic discovery. For example, if it's a violation under the vehicle and traffic law, that's considered to be a traffic infraction. Or if it's a petty offense where there's no statutorily authorized sentence of imprisonment, there's no need for automatic discovery. That said, the defense may file a motion for disclosure. They still have the ability to access records, but the prosecution is not going to need to abide by the requirements under the first bullet of the slide. What about civil cases? Well, those are much less structured. If you are involved in a civil case, you can request anything relevant to the case, but nothing is going to be provided automatically. It has to be requested if you want to receive a copy of it. And if that request seems to be inappropriate or way too broad given the subject matter of the case, you can request that it be modified. The deadlines for civil cases are case by case. Records can be requested by a certain date. And again, if that's unreasonable, it can be modified. And the window for submitting those requests is between when the plaintiff files the complaint and when the trial begins. You can still request records outside that period, but you're going to have to use a court order to do it. So how can we make this all easier? Jennifer already talked about the responsibilities of records management staff, but what can we do with the structuring of our records management programs to ensure that when that discovery demand comes in, we can respond quickly and fully? Well, especially with criminal matters where you know that there is going to be arraignment, you can think about how you create those records in the first place. Should they be prepared with an eye towards the eventual discovery? And should a copy that is going to be released to counsel or to the defense be prepared at the same time that you're preparing the original in-office use copy? Or does it make sense to create two copies at that point? Because you're going to have to create one for discovery anyway. So why not have the subject matter expert who understands the case, who's thinking about it right now, think about it then? You're also going to want to think about who needs to access that records as part of the response process and how you can provide that access appropriately. For example, do you need to make sure that counsel or IT staff are aware that something is coming so that they can access the records for review, potential redaction, potential duplication? And if you're already providing access, would it make sense to do it earlier on the assumption that counsel and others are going to need to access it? Does it make sense to just make sure that legal staff are able to access these records through their entire lifespan rather than waiting for a request to come in and having the subject matter experts and records custodians going through and identifying records and providing them in response at that point? In your office, does it make sense to ensure that counsel are able to do their own review to understand what's going on without having to contact the 1 or 5 or 10 people who might hold responsive records? This is a good process for anything related to records management, but especially when you're trying to access things quickly. You probably want to create a centralized process that's standardized. It's like, where are the records stored? Are they on the desks of all 20 staff in this particular unit? Or are they all in one location on a local area network, in a document management system, or in a file room? Do you know what's in each file? Or, whether it's a file folder or a filing cabinet? And do you know where they're stored? If you maintain a index of what should be in each box and where each box is located, it can be the difference between having to search through 20 boxes and having to go to the one correct box or the one correct file drawer. You may also want to consider assigning specific staff to do refiling, or, if you're a former library person like I am, you'll be familiar with the term shelf reading, which is when you go into the files or the stacks when you don't need to access something, just to spot check and make sure that everything is where it should be. Because if you have multiple people accessing the files, they may not understand the filing scheme, or they may just be distracted, and they may put things where they don't belong. And if you have specific staff who are responsible for making sure that records are exactly where they should be, it's going to make it easier to retrieve them. Just talking about creating an index, you may want to also create indexes to help you compile records in response to discovery requirements. You may want to say that for this particular case, for the, whether it's a civil case or a criminal case, these are all the records we need to collect. These are all the records we have. We have already documented that we know what we need and which ones we've already found and which ones we need to locate. You may also want to create more general indexes for different types of actions or decisions, to say when this type of case is brought against us, or when we're assuming that we're going to bring one of these cases against someone else, this is the type of record that we need to have as part of that discovery response or as part of that legal file. And it will be a great reference for you to be able to determine, yes, we've pulled everything, or maybe there are things that have been misplaced or that we just haven't had the time to pull yet. So that you're able to have that cheat sheet and document what you have already and what you need to locate still. And of course, again, a basic records management concept. If staff are pulling records from the file room so that they can access the information within them and do their jobs, it's good to track where those records have gone, so that if you do need to retrieve them, you know who to go to, how long they've had them, and what process you need to go through to, again, access that information. You may also want to consider your filing system and whether it's serving your needs. For example, if you are now having to think of records in a different way, if you're pulling different records, then you might have to reassign file names or come up with a new order where things are grouped together. If you're always pulling the same things together, you may want to keep them together, for example. You can also think about whether the file format in which things are kept serves your needs. For example, if you're going to be doing a lot of redaction, it's probably going to be easier if those records are already in electronic format. Likewise, if you're sharing records with individuals elsewhere in the office or in other offices, it might be easier to transmit them if they're in electronic format. And finally, if you're worried about people misfiling things or checking out records and not returning them, you might not have as much of an issue if they're in electronic format. I used to be a records access officer. I've done a lot of redaction in my time, and I am a big fan of designing documents when possible for ease of review and redaction. If you're a reviewer and you're having to go through hundreds or thousands of pages, you don't want to have to search for restricted content. You're going to want to make sure that, if at all possible, that information is on the same place in every document. And if you do that, not only does it make it easier for human redactors, but depending on what tool you're using, you may actually be able to train it to identify a specific place on the page where it contains information that needs to be redacted and have it automatically apply redactions to that section of the page. So we're almost done, though we're going to open up for questions, but just a brief summary before we do. Records managers are so often involved in identifying and locating records of potential litigation, because you're the subject matter experts on what types of records are created by who and where they're stored. If you receive a litigation hold, you need to halt routine disposition. It does not matter if the record could have been destroyed yesterday or 2 years ago. You need to make sure that disposition stops until that hold is lifted. And if you're a local government, you actually need to hold those records for a year after the hold is lifted. Speaking of litigation holds, they apply to all record formats and locations. It does not matter if they are emails, if they are paper documents, if they are stored with staff in the regional office, if they're stored with a consultant who's working on behalf of your organization. If they are your records and they relate to this matter of the case, they are subject to the hold and need to be held. And finally, planning ahead about your filing system, about how you create records, about how you organize records, can significantly reduce the time needed to respond to discovery demands and subpoenas. And I like to say good records management means that people are not frustrated because they are able to access the information they need quickly. And, especially with something like this where there are tight deadlines to respond, you want to make sure that everyone who needs information can find that information and be confident that it is all the information related to that matter with minimal effort. If you have questions for State Archives staff, the person you contact differs based upon what type of government you are. If you're a state agency, you contact Jennifer and her colleagues in the Scheduling State Agency Services Unit. And I believe Rich is going to put the email address for that in the chat. It's recmanagement@nised.gov. If you're a local government, you get to work with the Records Advisory Officer. For example, if you're a city, a fire district, or a New York City municipal agency, you work with Maria McCashin. If you're a county, a library, or a miscellaneous government, everyone from housing authorities to soil and water conservation districts, you work with me. Schools, BOCES, community colleges, and other educational entities work with Rich Hahn. Michael Martin works with towns. And then we have, a couple of interim assignments. If you're a village, you're working with Maria, and I'm helping out the Cornell Cooperative Extensions. And hopefully within the next few months, we'll be able to introduce you to a new person who will be taking on those roles. And now we're going to open things up for questions. Rich, do we have anything in the chat?
Yes, Monica, I have a couple of questions here. We had a question early on from Robert. When will the next version of the retention and disposition schedule be available?
So I'm not exactly sure whether Robert is referring to the uh, general retention schedule, which is for state agencies, or the LGS1 schedule, which is for local governments. We are actively working on updates to the state general schedule, and I can't give you a definite timeline as to when the next version will be out, but we're hoping soon. In terms of the LGS1 for local governments, the last issuance of that was in 2022. We are always gathering potential revisions to that schedule and compiling them. So it won't be probably in the next 2 years that we produce a new version of that, but we hope to do so, maybe shortly after that.
Oh, and Jennifer, Robert was in fact referring to the general retention schedule.
Okay, so for state agencies, yeah, no definitive timeline, but we are working on it.
Okay, I had a question from Tracy as well a little early on. Can you provide the case law / court decision you are referencing? And I don't recall, you may have done that in the presentation.
Yeah, so I did refer to let's see, the Zubelok versus UBS Warburg. That you could just Google that and you can find this, specific court documents related to that and more information. I also referred to the Adult Survivors Act. Um, that again, you can Google that. That's a New York State law that was in effect probably a couple of years ago. There was that window that allowed claims to be retroactively applied. I did mention a couple of legal actions that we were working on with agencies, but I don't really want to throw any agencies under the bus, so I was trying to keep things fairly anonymous. But there were no like earth-shattering decisions that related to those.
Yeah, I think just Tracy just chimed in on that, just saying decision for records retention schedules are not an excuse for not having records.
Yeah, I don't know that that was necessarily a decision, but it sounds like it's just something that um, agencies have observed from the courts is that retention schedules and adoption of them is not sufficient proof of, destroying a record or not having a record. So I think it's just a good, seems like that's the direction that courts are leaning. So it's probably a good rule of thumb to also have additional safeguards in place, like documenting destruction and doing diligent searches across your records. I think that's a good rule of thumb for anyone to follow.
Okay, and you're welcome, Tracy. We still have about 8 minutes. If anybody has any additional questions to type in. And just wanted to let everybody know that, of course, this, as with all of our other New York State Archives webinars, is being recorded and will be available. You can access it from either our website or our YouTube page. I have a question here from Rebecca. If you are a new RMO and there is a grace period for us to get up to speed, is there? So if you are a new RMO, is there a grace period for us to get up to speed on our records for the municipality we are working?
As far as discovery is concerned, I wouldn't think there would be a grace period. As far as records management is concerned, speaking as somebody who works with local governments and has previously worked with and at state agencies, I think it's safe to assume that there are very few moments in time where anyone is going to be perfectly in compliance. It is a ongoing process. Records are, going to be coming up for to their minimum disposition date at any time. So really it's a matter of trying your best. And in your case, if you are new to the municipality, I really recommend that you reach out to your records advisory officer, and we can help you figure out how to make sure that the processes currently in place are, appropriate and whether there are modifications necessary. And we also are very happy to provide one-on-one guidance on how to manage your records.
Okay, thanks, Monica. And Rebecca says thank you. And again, folks, if you have any questions down the road, you can always email us at recmgmt@niced.gov, which we have up on the screen there. We love questions. We love helping our constituents out there and our partners in records management. So you can contact us at any time. I don't see any additional questions at all. So maybe we can give everybody 5 minutes of time back for their attention. Jennifer or Monica, any final words?
Well, I would like to thank everybody for their time. I really appreciate it. And I hope that everybody has a great day. Thank you.
Okay, thanks, Monica. And Rebecca, any final words? Jennifer or Monica, any final words? Jennifer or Monica, any final words?
I think just the same final words we have with every webinar. We are here to help you manage your records. This is something we are invested in, we care deeply about, and we are very happy to talk to you, and we are not scary. So please make friends with us. Contact the state agency services or your records advisory officer and build that relationship.
Well said, Monica. Thank you. Thanks everyone for attending.
Thank you, everyone.